Most accounts of this case begin in a bathroom in Bolingbrook, Illinois, in March of 2004. This one begins somewhere less cinematic, a municipal room in Will County, 2 months later. 6 ordinary citizens sitting through a coroner's inquest, a proceeding most Americans have never heard of and will never attend. They were not a criminal jury. They could not convict anyone. Their job was narrower and, in a sense, stranger. To listen to a summary of an investigation and put a single word on a death certificate. They chose the word accident. That decision, made by 6 people in an afternoon, based largely on what an investigator told them, determined the next 3.5 years of this case. It closed a file. It ended a criminal inquiry that had barely started, and it meant that when the story finally exploded into national news, prosecutors would be building a homicide case around a body that had already been buried, an autopsy already signed, and a crime scene that no longer existed. Understanding how that room reached that word is, I'd argue, the single most useful thing this case has to teach. Because Drew Peterson was eventually convicted. Kathleen Savio's death was eventually reclassified. The system eventually got there. The question worth 3,000 words is why it took so long and what the delay cost. To follow what happened, you need to understand a distinction that almost never gets explained in true crime coverage. The difference between cause of death and manner of death. Cause is the physical mechanism. Manner is the category. Natural, accidental, suicide, homicide, or undetermined. In March of 2004, the Will County Coroner's Office attributed Kathleen Savio's death to drowning. That was the cause. But the pathologist's report also contained a line noting that an injury to her head could be consistent with a fall in the tub, an observation that quietly pointed toward a manner which is not typically what a pathologist is asked to decide. Years later, at trial, the forensic pathologist who conducted the second examination testified that he found this unusual. In his view, that language had likely been added at someone's suggestion rather than arrived at independently. That is his professional opinion, offered under oath and contested by the defense, not an established fact. But it points at something real about how death investigations work. Forensic conclusions do not form in a vacuum. A pathologist works from the narrative investigators hand over. If the narrative that arrives is woman living alone, slipped in the bathtub, the physical findings get read against that story. This is a well-documented cognitive phenomenon, context bias in forensic interpretation, and it is one of the most studied weaknesses in modern death investigation. It is not corruption. It is how human attention works. When a frame is set early. The frame was set early here. The Illinois State Police Sergeant who led the 2004 investigation testified at trial that from the beginning, the working assumption around the case was accident. Not everyone shared it. A Will County deputy coroner later testified that the scene struck him as wrong, that he saw no signs of a fall or a struggle, that items in the bathroom were undisturbed, that the position of the body did not read to him like the aftermath of someone slipping. So, the misgivings existed. They were spoken aloud by a public official in the appropriate venue. They simply weren't decisive. There was a second oddity, reported in later accounts of the inquest. At least one member of that 6-person jury was a police colleague of Peterson's, who spoke well of him as a husband. Whether that shaped the outcome is unknowable. What it illustrates is structural. Bolingbrook in 2004 was a suburb where a long-serving sergeant was a known quantity, and an inquest panel was drawn from that same community. Years afterward, the Will County coroner said publicly that the death should have been ruled undetermined at minimum. That word matters more than it sounds. Undetermined is not an accusation. It is an open door. It keeps a file breathing, keeps evidence retained, keeps a case reviewable without anyone having to reverse a formal finding. The gap between accident and undetermined is the difference between a closed matter and a pending one. And in this case, it was the difference between 3.5 years of momentum and 3.5 years of silence. Here's the part of this case that has the most practical relevance to anyone watching, and the part that gets the least screen time in most retellings. The information that would later form the spine of the prosecution's case was, for the most part, already sitting in government filing cabinets in 2004. Kathleen Savio had obtained an order of protection in 2002, alleging a pattern of physical abuse and threats. Bolingbrook's police chief later told a national broadcast that the department had roughly 18 reports on file relating to the household, beginning around February of that same year. Savio had also told people close to her, repeatedly, according to testimony from friends and relatives years later, that she believed her husband could kill her and make it look like an accident. Read that back. A woman told multiple people she feared being killed in a way that would be mistaken for an accident. She then died in circumstances that were classified as an accident, and that connection wasn't drawn in 2004 because nobody in a position to act was holding both halves at once. This is the structural failure at the heart of the case, and it is not unique to Bolingbroke. Domestic violence reports have historically been processed as discrete incidents, a call, a report, a disposition, a file, rather than as data points in an escalating pattern. Each individual report looks minor in isolation. 18 of them look like something else entirely, but only if someone stacks them. Modern practice has moved toward exactly that stacking. Lethality assessment protocols, danger assessment instruments, and coordinated review teams now exist in many jurisdictions specifically to identify which domestic situations carry elevated risk of a fatal outcome. Strangulation history, separation, threats to kill, access to weapons, obsessive surveillance of a partner. These are weighted risk indicators, not background noise. Layer on one more complication. Peterson was a sergeant on the local force. Illinois State Police handled the death investigation for that reason, which was the correct call. But institutional caution around investigating an officer runs deeper than jurisdiction. It runs through who takes a complaint seriously, how a call gets coded, whether a woman reporting her husband believes anything will come of it. There was also history that apparently didn't travel with him. In 1985, Peterson was fired by Bolingbroke's Police and Fire Commission following findings that included disobedience, conducting a self-assigned investigation, failure to promptly report a bribe, and official misconduct. Related criminal charges were later dropped, and he was reinstated in 1986 after courts found the discipline excessive and the evidence insufficient. Legally, that's a closed matter with an outcome in his favor, and it should be described that way. Institutionally, it's something else, a documented, adjudicated concern about the same officer's judgment, sitting in a personnel file nearly 20 years before a death investigation in which his conduct was never seriously examined. On October 28th, 2007, Stacy Peterson, 23 years old, married to Drew, mother of 2 young children, was last seen. Her sister reported her missing. Peterson's account was that she had left him for another man. Her family rejected it immediately and never wavered. Illinois State Police moved quickly, and within days, a state police captain publicly characterized the case as a potential homicide and named Peterson as the suspect. To this day, no one has been charged in connection with Stacy Peterson's disappearance. She has never been found. That distinction has to stay sharp throughout any responsible telling of this story. Peterson was convicted of one crime against one woman, and he has never been charged in relation to the other. But the disappearance did something to the Savio file that no new physical evidence could have done on its own. It changed the prior. Think of it in plain terms. In 2004, investigators evaluated an unusual death against a background assumption. Unusual deaths in bathrooms are usually accidents, because statistically they are. In 2007, the same file was reread against a different background. This is the second wife of the same man to die or vanish under circumstances his own account has to explain. Almost nothing about the 2004 evidence changed. What changed was what that evidence was competing against. And that shift, the same facts becoming persuasive because the surrounding context moved, is one of the most important and least discussed dynamics in criminal investigation. Savio's body was exhumed in November of 2007. A second examination was conducted by a forensic pathologist for the coroner's office, with a separate review by a pathologist retained on behalf of the family. The conclusion reversed the original finding. The manner of death was reclassified as homicide. At trial, that pathologist testified that the pattern of injuries including their location on the body, was not what he would expect from a backward fall in a bathtub, and that bruising he examined appeared to have occurred within roughly a day of death rather than being older, as had earlier been suggested. Toxicology from both 2004 and 2007 showed no drugs or alcohol in her system, which undercut the theory that she had been impaired. It is worth being honest about what this evidence is and isn't. It is expert opinion, formed years after the fact, on remains that had been buried for 3.5 years, and it was vigorously disputed by defense experts who maintained the death was accidental. The defense's position was not absurd. It was, in fact, the position the state of Illinois itself had officially held until 2007. That's the uncomfortable symmetry at the center of this case. For 3.5 years, the government's own conclusion was the defense's theory. Then came the part that made this a national story rather than a regional one. Peterson did not go quiet. He did the opposite. He gave interviews. He joked with reporters camped outside his home. He hired a spokesman. He treated a swarm of press cameras as an audience rather than a threat. And for a while, a certain segment of the media rewarded him for it. The suspect who talked endlessly and made good television doing it. There is a strategic logic buried in that behavior, and it is worth naming rather than simply gawking at. An innocent person under suspicion often has an incentive to speak. A guilty person sometimes calculates the same way on the theory that visible ease reads as innocence, and that a man behaving as though he has nothing to hide will be perceived as a man with nothing to hide. It worked in the short term. It was catastrophic in the long term. Here's why. Every performance generated coverage. Coverage kept the case in the public consciousness. Public pressure sustained investigative funding and political will in a case with no body, no confession, and an official finding of accidental death already on the books. Peterson's own appetite for attention helped keep alive the investigation that eventually convicted him. In January 2012, 6 months before jury selection in his murder trial, a major cable network aired a dramatized television movie about him with a well-known actor in the lead role. Read that sequence again. A nationally distributed dramatization of a defendant's alleged conduct, broadcast to a mass audience before the jury in his actual trial had been seated. Whatever you think of Peterson, that raises a real question about pre-trial publicity that most coverage of this case simply skipped past. Courts manage publicity through voir dire, jury instruction, and occasionally a change of venue. Those tools were designed for newspapers and local broadcasts. They were not designed for a primetime feature film about the defendant. Media entanglement reached the defense table too. On appeal, Peterson's lawyers argued that his lead trial attorney had a conflict of interest arising from a media contract related to the case. The Illinois Supreme Court rejected the argument, finding it did not amount to a per se conflict. And there was a subtler distortion. Because Stacy's disappearance drove the coverage, enormous numbers of people came to believe Peterson was on trial for something he was never charged with. He was tried for the death of Kathleen Savio. The public conversation then and now is frequently about Stacy. That confusion is worth correcting every time it appears, for accuracy and out of basic respect for a woman whose death was very nearly written out of her own case. Now to the piece that criminal law professors still teach, and which almost no documentary explains properly. Prosecutors faced a problem that looked close to fatal. Their two best witnesses were a woman who was dead and a woman who was missing. Kathleen Savio had told friends, relatives, and officials what she feared. Stacy Peterson had spoken to a pastor about her husband's movements on the night in question and had spoken to a divorce attorney about the same subject. All of it was hearsay. Under normal rules, none of it comes in, because the defendant has a constitutional right to confront the witnesses against him, and you cannot cross-examine the absent. In 2008, the Illinois legislature passed a statute that the press promptly nicknamed Drew's Law, creating a pathway to admit statements of unavailable witnesses under defined conditions. Here is the twist that gets lost. When the case reached the Illinois Supreme Court in 2017, the court held that the admissibility of those statements was governed not by the new statute, but by the common law doctrine of forfeiture by wrongdoing embodied in the Illinois Rules of Evidence. Forfeiture by wrongdoing is centuries old. Its principle is blunt. A defendant who wrongfully makes a witness unavailable forfeits the right to object to that witness's out-of-court statements. You cannot silence someone and then demand the protection of their silence. The famous headline, "Illinois passed a law to convict one man," is therefore not quite right. What actually happened is more interesting. An old doctrine was applied to a modern domestic violence fact pattern, and the appellate courts affirmed a demanding version of it. The state does not have to identify the specific testimony the defendant was trying to prevent in order to establish intent. Intent can be inferred from surrounding circumstances, drawing on United States Supreme Court reasoning that acts of domestic violence are often themselves designed to prevent a victim from seeking outside help. Follow the logic to its end, and you land somewhere genuinely difficult. A trial judge must make a preliminary finding that the defendant likely caused the witness's unavailability in order to admit the evidence that helps prove he did it. That is not circular reasoning in the technical sense. The standards of proof at the two stages differ, and appellate courts have upheld the structure. But it is legitimately close to the line, and thoughtful defense lawyers have been arguing about it ever since. This case is now a citation, not just a story. The 2012 trial ran roughly 5 weeks. The state called more than 30 witnesses. There was no physical evidence placing Peterson at the scene. No eyewitness, no confession. Jurors heard the pastor's account of what Stacy told him about her husband leaving the house in the middle of the night around the time of Savio's death. They heard from a man who testified that Peterson had asked whether he knew anyone who could have his third wife taken care of, with a sum of money mentioned. They heard the forensic reinterpretation. They heard from Savio's circle about what she had predicted would happen to her. And then the defense called Stacy's divorce attorney. The stated aim was to undercut the pastor's credibility. What the jury got instead was testimony that Stacy had asked her attorney whether she could obtain more in a divorce by threatening to tell police how her husband had killed his previous wife. It is difficult to overstate how damaging that was. It arrived through the defense's own witness, which stripped away any suggestion that prosecutors had manufactured it. On appeal, Peterson argued this constituted ineffective assistance of counsel. The courts disagreed, not because the decision looked wise in hindsight, but because of how the legal standard operates. Under the governing framework, a defendant must show that counsel's performance fell below an objective standard of reasonableness, and that the outcome would likely have been different otherwise. Reviewing courts extend broad deference to anything that can be characterized as strategy, precisely to prevent every losing defendant from relitigating tactics. The Illinois Supreme Court found the decision to call that witness fell within the realm of trial strategy. It also held that attorney-client privilege did not bar the testimony, because the attorney had declined to represent Stacy. That's the practical lesson buried in the appeal. Disastrous and ineffective are not synonyms in American criminal law. A strategy can fail spectacularly and still be constitutionally adequate. The jury convicted on September 6, 2012. In February 2013, Peterson was sentenced to 38 years. An appellate court affirmed in 2015. The Illinois Supreme Court affirmed in 2017. In 2016, Peterson was convicted again, this time of solicitation of murder for hire, for attempting to arrange the killing of the Will County State's attorney who had prosecuted him. He received an additional 40 years to be served consecutively. Combined, the sentences run so long that public records list his earliest possible release date in 2081, when he would be well past a century old. He has been held out of state under an interstate corrections agreement, with corrections officials declining to confirm his location, citing his identity as a former officer. In 2021, he filed a handwritten petition seeking a new trial, arguing his lead attorney refused to let him testify. A judge found enough in it to proceed. Public defenders were appointed. The litigation has crawled through discovery for years, survived the retirement of the original judge, and included a court-ordered fitness evaluation, after which the judge indicated he saw nothing suggesting Peterson was unfit to participate. Along the way, his former lead attorney publicly suggested He might disclose what he knew, drew a gag order, and faced contempt proceedings and a special prosecutor. Stacy Peterson has still not been found. Searches have been conducted repeatedly over the years, including of canal waters near Lockport, without result. Her sister has never stopped looking and has continued organizing searches nearly 2 decades on. One of Peterson's sons, himself later fired from a suburban police department over conduct connected to the investigation, told the Chicago Tribune in 2017 that he had come to believe his father was responsible for both women, while noting that his father has never confessed and continues to maintain his innocence. Strip away the tabloid noise, and what remains is a case about institutional attention. Kathleen Savio told people what she feared. She filed for an order of protection. Reports accumulated. A deputy coroner found the scene suspicious and said so. A coroner would later say the ruling should have been left open. None of that was hidden. All of it was in the system. And a manner of death was still recorded as accident by 6 people in a room on the strength of a summary from investigators who had settled on that answer early. The correction came, but only because an unrelated tragedy forced a second look, which means the correction was, in a real sense, accidental itself. That should sit uncomfortably with anyone who assumes the system self-corrects on its own schedule. The reforms that followed were partly legal and partly cultural. Illinois grappled publicly with how to handle the testimony of victims who cannot testify. Death investigation practice has moved toward greater independence between pathologists and investigative narratives. Domestic violence policing has moved unevenly toward pattern recognition instead of incident processing. But there's a limit to how much comfort that offers, because the most consequential decision in this entire case cost almost nothing to get right. Not a task force, not a new statute, one word on a certificate. Undetermined instead of accident, a phrase that accuses nobody and closes nothing. Kathleen Savio was 40 years old. Stacy Peterson was 23 and is still missing. Whatever else this case produced, the trials, the doctrine, the coverage, the movie, those 2 facts are what it actually is. If a coroner's jury in 2004 had returned a verdict of undetermined instead of accident, do you think this case would have been solved years earlier? Or do you think the outcome depended entirely on Stacy Peterson's disappearance forcing a second look? Let us know how you see it. Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.